Two, three, four.
Good evening, everybody. How's it going? All right. Today, don't do a repeat. Stop the repeat. Stop it. Damn you. Oh well. All right. We'll get that locked down eventually. We will figure that out one way or the other. All right. So today we are reading from the Conflicts of Laws book. We are reading particularly about. There we go. We're reading about the problem of special judgments for conflict of laws, and it's the number one problem here is ex parte divorce. And so we will be talking about the case of Estin versus Estin, a Supreme Court case from 1948, right after World War II ended, huh? All right. So Justice Douglas, our old buddy, delivers the opinion of the court again, huh? All right. Opinion of the court by Justice Douglas, announced by Justice Reed. So I guess Douglas was drinking or something. This case here on certiorari from the Court of Appeals of New York presents an important question under the full faith and credit clause of the Constitution, Article 4, Section 1. It is whether a New York decree awarding the respondent $180 per month for her maintenance and support in a separation proceeding survived a Nevada divorce decree which subsequently was granted to the petitioner. The parties were married in 1937 and lived together in New York until 1942, when the husband left the wife. There was no issue of the marriage. In 1943, she brought an action against him for separation. He entered into a general appearance in the court, finding that he had abandoned her, granted her a decree of separation and the award of $180 a month as a permanent alimony. In January of 1944, people were going to World War II. He was going to Nevada, where in 1945, he instituted an action for divorce. She was notified of the action by constructive service, but not entered into an appearance in Nevada. In May 1945, the Nevada court, finding the petitioner had been a bona fide resident of Nevada since January 30th of 1944, granted him an absolute divorce on the ground of 3 years continual separation without cohabitation. The Nevada decree made no provision for alimony, though Nevada court had been advised of the New York decree. Prior to that time, the petitioner had made payments of alimony under the New York decree. After the entry of the Nevada order, he ceased paying. Thereupon, he moved to New York for a supplementary judgment for the amount of the She didn't move to New York. He didn't move to New York. She submitted to the New York court for a decree of judgment for the supplementary amount of all the back pay of the alimony that he owed her. The Supreme Court, which is the lowest court in New York, not the highest court, denied the motion and granted respondent judgment for the arrears. The judgment was affirmed by the Appellate Division, which is their appeals court, and then by the Court of Appeals, which is the Supreme Court of New York. The highest court is the Court of Appeals. We held in Williams v. North Carolina that a divorce decree granted by a state to one of its domiciliaries is entitled to the full faith and credit in a bigamy prosecution brought in another state, even though the other spouse was given notice of the divorce proceeding only through constructive service, and two, that while finding a domicile by the court that granted the decree is entitled to prima facie weight, it is not conclusive and a sister state might be relitigated there. The latter course was followed in this case, as a consequence of which the Supreme Court of New York found, in accord with the Nevada court, that the petitioner is now and has since January of 1944 been a bona fide resident of the state of Nevada. Petitioner's argument, therefore, is that the tail must go with the hide. That since by Nevada decree recognized in New York, he and respondent are no longer husband and wife, no legal indice of the marriage remains. We are given a detailed analysis of New York law to show that New York courts have no power, either by statute or by common law, to compel a man to support his ex-wife, that alimony is payable only so long as a relation of husband and wife exists, and that in New York, as in some other states, a support order does not survive a divorce. Here we go. The difficulty with that argument is that the highest court in New York has held in this case that a support order can survive divorce, and that this one has survived the petitioner's divorce. That conclusion is binding on us, except as it conflicts with the full faith and credit clause. It is not for us to say whether that ruling squares with what the New York court said on earlier occasions. It is enough that New York today says that such is her policy. The only question for us is whether New York is powerless to make such a ruling in view of the Nevada divorce decree. We can put to one side the case where the wife was personally served or where she appeared in the divorce proceedings. The only service on her in this case was by publication, and she made no appearance in the Nevada proceeding. The requirements of procedural due process were satisfied, and the domicile of the husband in Nevada was the foundation for a decree affecting a change in the marital capacity of both parties in all the other states in the Union, as well as in Nevada. But the fact that the marital capacity was changed does not mean that every other legal incidence of the marriage was necessarily affected. Although the point was not adjudicated in Barber v. Barber, another case, the court in that case recognized that while a divorce decree obtained in Wisconsin by a husband from his absent wife might dissolve the vicumi of the marriage, vinculum of the marriage. I'll have to look it up. It does not mean that he was freed from payment of the alimony under an earlier separation decree granted in New York. An absolutist might quarrel with the result and demand a rule that once a divorce is granted, the whole of the marriage relation is dissolved, leaving no roots or tendrils of any kind. But there are few areas of the law that are black and white. The grays are dominant, and even among them are shades innumerable. For the eternal problem of the law is one of making accommodations between conflicting interests. This is what most legal problems end as questions of degree. That is true of the present problem under the full faith and credit clause. The question involves important considerations both of law and policy, which is essential to the state. The situations where a judgment of one state have been denied full faith and credit in another state because its enforcement would contravene the latter's policy have been few and far between. The full faith and credit clause is not to be applied accordion-like to accommodate our personal predilections. It substituted a command for the earlier principles of comity and thus basically altered the status of the states as independent sovereigns. That's quoting from Williams v. North Carolina. It ordered submission by one state even to hostile policies reflected in the judgment of another state, because the practical operation of our federal system, which the Constitution designed, demands it. The fact that the requirements of full faith and credit, so far as judgments are concerned, are exacting, if not inexorable, does not mean, however, that the state of the domicile of one spouse may, through the use of a constructive service, enter a decree that changes every legal instance of the marriage relationship. Marital status involves the regularity and integrity of the marriage relation. It affects the legitimacy of the offspring of a marriage. It is the basis of criminal laws, as the bigamy prosecution was in Williams v. North Carolina, dramatically illustrating. The state has a considerable interest in preventing bigamous marriages and in the protecting of offspring of marriages from being bastardized, not having a dad. They don't care about that anymore. The interest of states extends to its domiciliaries. The state should have the power to guard its interest in them by changing or altering their marital status and by protecting them in that changed status throughout the farthest reaches of the nation. For a person domiciled in one state should not be allowed to suffer the penalties of bigamy for living outside the state with the only one which the state of his living outside the state with the only one which the state of his domicile recognizes as his lawful wife. The children born of the only marriage which is lawful in the state of his domicile should not carry the stigma of bastardry when they move elsewhere. These are matters of legitimate concern to the state of the domicile. They entitle the state of the domicile to bring in the absent spouse through constructive service. In no other way could the state of the domicile have and maintain effective control over the marital status of its domiciliaries. Those are the considerations that have long permitted the state of the matrimonial domicile to change the marital status of the parties by an ex parte divorce. And that's quotes from Thompson v. Thompson, which considers the Williams case. We thought were equally applicable to any state in which one spouse had established a bona fide domicile, but those considerations have little relevancy here. In this case, New York evinced a concern with this broken marriage when both parties were domiciled in New York and before Nevada had any concern with it. New York was rightly concerned lest with the abandoned spouse be left with impoverished and perhaps become a public charge. The problem of her livelihood and support is a plain matter which her community and a legitimate interest in the state of New York exists. The New York court having jurisdiction over both parties, undertook to protect her by granting her a judgment of permanent alimony. Nevada, however, apparently follows the rule that dissolution of the marriage puts an end to a support order. But the question is whether Nevada could, under any circumstances, adjudicate the rights of the respondent under the New York judgment when she had not personally been served and did not appear in the Nevada proceeding. Quoting from Bassett v. Bassett, another federal Second Circuit case, held that Nevada could not. We agree with that view. The New York judgment is a property interest of the respondent, created by New York in a proceeding which both parties were present. It imposed obligations on the petitioner and granted rights to the respondent. The property interest which it created was an intangible jurisdiction over which cannot be exerted through control over a physical thing. Jurisdiction over the intangible can indeed only arise from control or power over the persons whose relationships are the source of those rights and those obligations. Jurisdiction over a debtor is sufficient to give the state of its domicile some control over the debt which he owes. It can, for example, levy a tax on his ability to on his transfer of will, appropriate it through garnishment or attachment, collect it and administer it for the benefits of the creditors. But we are aware of no power which the state of domicile of the debtor has to determine the personal rights of the creditor in the intangible unless the creditor has been personally served or appears in the proceeding before the petitioner. We know of no source of power which would take the present case out of that category. The Nevada decree said that to wipe out the respondent's claim for alimony under the New York judgment is nothing less than an attempt by Nevada to restrain the respondent from asserting her claim under that judgment. That is an attempt to exercise an in personam jurisdiction over a person not before the court. That may not be done. Since Nevada had no power to adjudicate the respondent's rights in a New York judgment, a judgment of a court having no jurisdiction to render it is not entitled to the full faith and credit clause which the Constitution and statutes of the United States demand. The result in this situation is to make the divorce divisible, to give effect to the Nevada decree insofar as it affects the marital status, and to make it ineffective on the issue of alimony. It accommodates the interests of both Nevada and New York in this broken marriage by restricting each state to the matters of her dominant concern. Since Nevada had no jurisdiction to alter the respondent's rights in a New York judgment, we do not reach further question of whether, in the event, the judgment would be entitled to full faith and credit in Nevada, and it would be a time to consider that effect of any discrimination shown to out-of-state ex parte divorces when the state makes such a policy. Affirmed. All right. So basically what the court said there, right, is the court said that you had homeboy and his wife were living in New York. They were married there. They separated there. They filed the separation agreement. They went to the court. The court said, we're going to make you pay her $180 a month of alimony for the rest of her life. And you have a separation order. Now, he then bounced to Nevada after they separated. He lived in Nevada. They weren't legally divorced. They were just separated. He went to Nevada, stayed there for a full year, and after that full year, when he became a bona fide citizen of Nevada, he filed for divorce in a Nevada court, and they granted him his divorce. So then he went back to New York and said, hey, look, the separation agreement was still part of the marriage. We're still married, separated. That's where he gave you the alimony judgment. So now, here's a divorce decree. We're divorced. I don't have to pay you any alimony anymore because that was a term of our separation agreement. We're not separated. We're not married. We're not separated anymore. We're divorced. And then the Supreme Court steps in and says, no. You can go ahead and get your divorce in Nevada. You're now divorced. But the judgment for alimony that was entered in the separation agreement in New York, you still have to pay that. And the reason the court says could fix that, if he would have called her up and be like, hey, I'm suing you in Nevada, and I want to have a court hearing. Come out here, baby, to Nevada and have a court hearing. And if she would have set foot in Nevada or showed up in court in Nevada, the Supreme Court says then she would have been able to have the alimony taken from her by that divorce. But because she was never served, was never noticed about that hearing in Nevada, and never showed up, the Supreme Court says he gets his divorce, she gets her alimony, you get a car, and that's that. All right. Next case is similar. It's May versus Anderson, a 1953 U.S. Supreme Court case. Again, it's on divorce of some sort, and we have a custody case and a child support case to finish off tonight. So fun. All right. Judge Burton in 1953 delivered the opinion of this court. The question presented is whether a habeas corpus proceeding attacking the right of a mother to retain possession of her minor children in Ohio court, may give full faith and credit to Wisconsin decree which awarded the custody of the children to their father when that decree was obtained by the father in an ex parte divorce action in Wisconsin court which had no personal jurisdiction over the mother. For the reasons hereafter stated, the answer is no. So y'all know ex parte hearing it literally means without one of the parties. So if I were to go into court and be like, hey, my wife, I'm not going to be here, but I want you to do something. I want you to divorce me from her. I'm going to sue her for breaking my leg because she didn't shovel the walk, so I slipped and fell. So it's a tort action for negligence. Like, you can't have a proceeding with only one party. An ex parte hearing is an extreme thing granted only when the other party can't be brought into court. But it looks like what happened here is Daddy and Mommy lived in Ohio. Daddy bounced to Wisconsin. Daddy got Wisconsin to enter a divorce decree and get him custody of the children without Mommy being there and knowing about it. So here we go. The parties, Leona Anderson May and Owen Anderson, were formerly married in Wisconsin. Okay, so maybe I got my states wrong. But they were there resided together until December of 1946, World War II times. At that time, the couple agreed that Leona should take their 3 children to Ohio so that she could think over the future of her course. In January of 1947, Leona decided to stay in Ohio, and when she informed Owen of this decision, he filed suit in Wisconsin seeking a decree of divorce and award of the custody of the children. Leona received a copy of the summons and a petition, but she did not participate in the proceedings. In February 1947, the Wisconsin court granted the divorce and awarded the custody of the children to Owen, subject to a right by Leona to reasonable visitation. Owen then took the decree to Ohio, where he demanded and obtained the children with the assistance of some local police officers. In July 1951, so 4 years later, the children visited their mother in Ohio, and she refused to surrender them. Owen filed a petition for a writ of habeas corpus. Habeas corpus literally means produce the body. So he filed a writ, it means the court make her produce the bodies of the children, the live bodies, not the dead bodies, the live bodies of the children. Ohio procedure, the writ tests only the immediate right to possession of the children and does not permit either the modification of a past custody award or a settling of rights to future custody. The probate court decided that it was obliged to the full faith and credit clause to accept the Wisconsin decree as binding upon the mother. Accordingly, it ordered the children discharged from further restraint by her, but the order has been held in abeyance pending appeal. So that, yeah, you got to give them back. It's our law. And then she appealed it, like, okay, well, while you're appealing it, we're not going to make you do it. So wait till the Supreme Court decides. Separated as our issue is from the future interests of the children, basically the children are getting lost in this whole thing, right? We have before us the elemental question of whether a court of a state where a mother is neither domiciled nor resident nor present may cut off her immediate right to the custody, care, management, and companionship of her minor children without having jurisdiction over her in personam. Rights far more precious to appellant than property rights will be cut off if she is bound by the Wisconsin award for custody. Quote, it is now too well settled to be open to further dispute that the full faith and credit clause and the act of Congress passed pursuant to it did not entitle a judgment to in personam to extraterritorial effects if it be made to appear that it was rendered without the jurisdiction over the person sought to be bound by it. And it was quoting from Estin and Estin we just read in Kreger v. Kreger. The court upheld the validity of a Nevada divorce obtained ex parte by a husband resident in Nevada, insofar as it dissolved the bonds of matrimony. At the same time, we held Nevada was powerless to cut off, in that proceeding, a spouse's right to financial support under the prior decree of the New York State. In the instant case, we recognize that a mother's right to the custody of her children is a personal right, entitled to at least as much protection as a right to alimony. In the instant case, the Ohio courts gave weight to the appellee's contention that the Wisconsin award of custody binds the appellant because at the time it was issued, her children had a technical domicile in Wisconsin, although they were neither residential nor present there. We find it unnecessary to determine the children's legal domicile because, even if it were to be with the father, that does not give Wisconsin certainty against Ohio. The personal jurisdiction that it must have in order to deprive the mother of her personal right to the immediate possession of the children. The judgment of the Supreme Court of Ohio accordingly is reversed, and the case is remanded to it for further proceedings not inconsistent with this opinion. We have a dissent here. We have two dissents. We have Justice Jackson, not our present Justice Ketanji Jackson, just Justice Jackson, the old G. Jackson, and Justice Reed dissents. The court apparently is holding that the federal constitution prohibits Ohio from recognizing the validity of the Wisconsin divorce decree insofar as it settles the custody of the couple's children. In the light of settled and unchallenged precedents of this court, such a decision can only rest upon the proposition that Wisconsin's court had no jurisdiction to make such a decree binding upon the appellant. A conclusion that a state must not recognize a judgment of a sister commonwealth involves very different considerations than a conclusion that it must do so. So basically, if you're saying, Ohio, you got to obey Wisconsin's law, the dissent here says, we've done that before, we're okay with that. But to say, hey, Ohio, you don't have to obey Wisconsin's law or their courts or anything, they're like, that's going to cause some problems, and we'll see why here. If Wisconsin has rendered a valid judgment, the Constitution not only requires every state to get full faith and credit, but 28 U.S.C. 1738, referring to such judicial proceedings, commands that they shall, quote, have the same full faith and credit in every court within the United States and its territories and possessions as they have by law or usage in the courts of such a state, territory, or possessions from which they are taken. So basically, Guam, wherever the U.S. has footing, right? Something happens in a court for custody or for whatever in Georgia. That goes for all 50 states, Puerto Rico, Guam, the Solomon Islands, Virginia, the Virgin Islands, wherever there's an American interest. All right. The only escape from obedience lies in a holding that the judgment rendered in Wisconsin as least to custody is void and entitled to no standing even in Wisconsin. It is void only if it denies due process of law. Ohio courts reasoned that although personal jurisdiction over the wife was lacking, the domicile of the children in Wisconsin was a sufficient personal jurisdictional basis to enable Wisconsin to bind all the parties that are interested in the child custody. This determination that the children were domiciled in Wisconsin has not been contested by the wife, either at the Supreme Court or at lower courts. Therefore, under our precedents, it is conclusive. The husband plaintiff in this case was at all times domiciled in Wisconsin. The defendant wife was a Wisconsin native, was married there, and both were domiciled in that state until her move in December of 46, when the parties stipulate that she acquired an Ohio domicile. The children were born in Wisconsin, were always domiciled there, and were physically resident in Wisconsin at all times until December 46, when the mother took them to Ohio with her. But the Ohio court specifically found that she brought the children to Ohio with the understanding that if she decided to not want to go back to Wisconsin, the children were bound to return to the state. In spite of the fact that she decided not to return, she kept the children in Ohio. It was under these circumstances that the Wisconsin decree was rendered in February of 47, less than 2 months after the wife had given up her physical residence in Wisconsin and held the children out of the state in breach of her agreement. The difference between the proceeding involving the status, custody, and support of children and one involving the adjudication of property rights is too apparent to require elaboration. In the former, courts are no longer concerned primarily with the proprietary claims of the contestants for the res, which is the property, before the court, but with the welfare of the res, which is the children itself. Custody is viewed not with the idea of adjudicating rights in children as if they were chattels, cows, sheep, something you can move around, right? But rather with the idea of making the best disposition possible for the welfare of each of the children. To speak of the courts cutting off a mother's right to custody of her children as if it raised problems similar to those involving cutting off her rights in a plot of ground is to obliterate these obvious distinctions. Personal jurisdiction of all parties to be affected by a proceeding is highly desirable, to make certain that they have valid notice and the opportunity to be heard. But the assumption that somehow overrides all the other considerations, and in the absence, a state is constitutionally impotent to resolve questions of custody, flies in the face of all of our Supreme Court cases. Well, that was the second one. We got a child support and custody case coming up here. Let me flip there and have a little bit of a drink here. Yep. Okay, this one's not so long. It's a good 4-pager. We're good. This is Yarborough v. Yarborough, 1933 case, U.S. Supreme Court. So this is like Great Depression era type case, 1933. All right. Go Depression era cases. Okay. Justice Brandeis delivers the opinion of the court. On August 10th of 1930, Sadie Yarborough, then 16 years of age, was living with her maternal grandfather, R.D. Blowers, at Spartanburg, South Carolina. I've been through there. Suing by him as guardian ad litem, she brought this action. So that means she's 16. She's living in South Carolina with her uncle, R.D. Blowers, in Spartanburg. They've appointed him as her guardian ad litem to be her representative because she's not an adult yet, right? And so he's the one suing on her behalf in this action to require her father, W.A. Yarborough, a resident of Atlanta, Georgia, to make provision for her education and her maintenance. She alleged that, quote, that she is now ready for college and is without funds, and unless the defendant makes provision for her, will be denied the necessities of life and of an education, and will be dependent upon the charity of others. There's a footnote here that says, there was no suggestion that plaintiff would be destitute or become a public charge. Indeed, her grandfather testified that he was able and willing to provide $125 a month for her education and maintenance, which was the amount exactly sought by the plaintiff from her father. And $125 in 1930 dollars. Somebody in the chat look that up or Google that or whatever. $130 in 1930 is worth what today? A lot. All right. Later, jurisdiction was obtained by attachment of the defendant's property. Later, he was served personally within South Carolina. In bar of the action, W.A. Yarborough set up, among other defenses, a judgment entered in 1929 by the Superior Court of Fulton County, Georgia, Atlanta, in a suit for divorce brought by him against Sadie's mother. He alleged that by the judgment, the amount thereafter paid by him for Sadie's education and maintenance had been determined, that the sum so fixed had been paid, and that the judgment had been fully satisfied by him. He claimed that in Georgia, the judgment was conclusive of the matter here in controversy, that having been satisfied, it was relieved of him, under the Georgia law, of all obligation to provide for the education and maintenance and well-being of the minor child, and that the full faith and credit clause of the federal Constitution required the South Carolina court to give to the judgment the same effect in this proceeding as it had and would have had in Georgia. The trial court denied this claim, ordering W.A. Yarborough to pay the grandfather as a trustee for the child $50 monthly for Sadie's education and support, and to pay $300 as fees for her lawyer who filed this. For some time prior to June 1927, W.A. Yarborough and his wife and their daughter Sadie had lived together in Atlanta, Georgia, where he then was and ever has since been domiciled. In that month, Sadie's mother left Atlanta for Hendersonville, North Carolina, where she remarried during that summer. Sadie joined her after there with a short stay at a camp. In September 1927, while they were at Hendersonville, West Virginia, Hendersonville, W.A. Yarborough, that's the guy's initials, not Washington, not West Virginia. Well, they were at Hendersonville. W.A. Yarborough brought in the Superior Court of Fulton County, Atlanta, a suit against his wife for a total divorce on the ground of mental and physical cruelty. Mrs. Yarborough filed an answer and also a cross suit in which she prayed a total divorce, the custody of the child, and, quote, that provision for permanent alimony be made for the support of the respondent and the minor child above so mentioned, named Sadie, and for the education of same minor child, end quote. An order, several times modified, awarded the wife the sole custody of Sadie as a temporary alimony sums, quote, for the support and maintenance of herself and the minor daughter Sadie, end quote. Hearings were held from time to time in Atlanta. At some of these, Sadie, but also her grandfather, were present personally. But she was not formally made a party to the litigation, she was not served with process, and no guardian ad litem had yet been appointed for her. A decree of total divorce with the right in each party to remarry was entered on June 7, 1929. The wife was ordered to pay the cost, and the jurisdiction of the case was, quote, retained for the purpose of further enforcement of the orders of the court theretofore passed. Among such orders was the provision for the maintenance of the education of Sadie, here relied upon as res judicata. Already decided, it means. It was entered on January 17, 1929, after the rendition of the first verdict. It was contended below in the trial court that there held that a provision of the decree for the Georgia court directing a payment to R.D. Blowers, the trustee, of $1,750 to be, quote, expended by him in his discretion for the benefit of the minor child, including her education, support, maintenance, medical attention, and other necessary items of expenditure, was not intended to relieve the father from all future liability to support Sadie. This contention appears to have been abandoned. It is clear that Mrs. Yarborough, her husband, and the court intended that this provision should absolve Sadie's father from future obligations to support her. That the term permanent alimony, as used in the decree of the Georgia court, means a final provision for the minor child is shown by both the legislation in the state and the decisions of its highest court. The refusal of South Carolina court to give the judgment effect as against Sadie is now sought to be justified on other grounds. The fact that Sadie has become a resident of South Carolina does not impair the finality of the judgment. South Carolina thereby acquired the jurisdiction to determine her status and the incidence of that status. Upon residents of that state, it can impose duties for her benefit. Doubtless, it might have been imposed upon her grandfather, who was resident there and has the duties to support Sadie. But the mere fact of the Sadie's residence in South Carolina does not give South Carolina the power to impose such a duty upon the father, who is not a resident and who long has been domiciled in Georgia. He has fulfilled the duty which he owes her by the laws of Georgia and the judgment of Georgia's courts. Upon that judgment, he is entitled to rely. It was settled by sister v. sister in U.S. 218 U.S. Supreme Court 1 that the full faith and credit clause applies to an intolerable decree of divorce. It applies to an untolerable decree of alimony for a divorced wife. The clause applies likewise to the intolerable decree of an alimony for a minor child. We need not consider whether South Carolina would have power to require the father, if he was domiciled there, to make further provision for the support, maintenance, or education of his daughter, because he's not domiciled there. And that's... Oh, no, I lied. We have a dissent. We have a dissent. Oh, happy days. 24 grand, that's like one semester of college. Well, it's rough. All right, we have Justice Stone's dissent. My bad. How could I forget about Justice Stone? I think the judgment should be affirmed, says Justice Stone. The divorce decree of the Georgia court purported to adjudicate finally, both for the present and for the future, the right of a minor child of the marriage to support and maintenance by directing the father to make lump sum payment for that purpose. More than 2 years later, after the minor had become domiciled resident of South Carolina, and after the sum had been paid in full, and she had exhausted that sum, a court of that state, on the basis of her need as then shown, rendered a judgment directing further payments for her support out of the property of the father in South Carolina. So Daddy owned property in South Carolina. This court started pulling money for her demands out of that value in South Carolina, rather. In addition to that already commanded by the Georgia judgment. For the present purposes, we may take it that Georgia decree, as the statutes and decisions of the state declare, is unalterable and has pronounced is effective and govern the rights of the parties in Georgia. So Daddy's paid it up. He's done in Georgia. That can't get more money out of him in Georgia. But there is nothing in the decree itself or the history of the proceedings which lead it to suggest that it was rendered with any purpose or intent to regulate or control the relationship of parent and child or the duties which flow from that in places outside of the state of Georgia, where they might later come to reside. It would hardly be thought that Georgia, by the judgment of its courts more than by its statutes, would attempt to regulate the relationship of parent and child domiciled outside the state of Georgia, the very time the decree was rendered, and, in the face of constitutional doubts that arise here, it is far from clear that its decree is to be interpreted as attempting to do more than to regulate that relationship while the infant continued to be domiciled within the state. But if we are to read the decree as though it contained a clause in terms restricting the power of any other state in which the minor child might come one day to reside, to make provision for her support, then, in the abeyance of some other law from Congress requiring it, I am not persuaded that the full faith and credit clause gives sanction to such a control by one state to the internal affairs of another state. Congress has said that the public records and the judicial proceedings of each state are to be given full faith and credit in other states, as to accord them the state which when they are taken. But this broad language has never been applied without limitations. See McElroy v. Cohen. Between the prohibition of the due process clause acting upon the courts of the state from which such proceedings may be taken, and the mandate of the full faith and credit clause acting upon the state to which they may be taken, there is an area which federal authority has not yet occupied. As this court has often recognized, there are many judgments which need not be given the same force and effect abroad which they have at home. And there are some, though valid in the state were rendered, to which the full faith and credit clause gives no force elsewhere. In the assertion of rights defined by a judgment state of any one state within the territory of another, there is often an inescapable conflict of interest between the two states, and there comes a point beyond which the imposition of the will of the one state beyond its own borders involves a forbidden infringement on some other legislative domestic interest of the other state. That point may vary with the circumstances of each case, and in the absence of provisions more specific than the general terms of the congressional enactment, this court might determine for itself the extent to which one state may qualify or deny the rights claimed in the proceedings or records that are brought in a different state. The question presented here is whether the support and maintenance of a minor child domiciled in South Carolina is so peculiarly a subject of domestic concern that Georgia law cannot impair South Carolina's authority. The subject matter of the judgment in each state is the duty which governors may impose on a parent to support a minor child. The maintenance and support of children domiciled within a state, like their education and their custody, is a subject in which the government itself is deemed to have peculiar interest and concern. Their tender years, their inability to provide for themselves, the importance to the state that its future citizens will be clothed, nourished, suitably educated, and are considerations which lead all civilized countries to assume some control over the maintenance of minors. The states very generally make some provisions from their own resources for the maintenance and support of orphans and destitute children. But in order that children may not become public charges, the duty of maintenance is one imposed primarily upon their parents, according to the needs of the child and their ability to meet those needs. This is usually accomplished by a lawsuit brought directly by some public officer, by the child's or by the guardian, or by a friend, or by the mother, against the father for maintenance and support of the child. The measure of the duty is the needs of the child and the ability of the parent to meet those needs at the very time when the performance of the duty is asked for. Hence, it is no answer in such a suit that at some earlier time provision was made for the child which is no longer available or suitable because of his or her greater needs, or because of the increased financial ability of the parent to provide for those needs, or that the child may be maintained from other sources. In view of the universality of these principles, it comes as a surprise that any state, merely because it has made some provisions for the support of a child, should either by a statute or judicial decree so tie its own hands as to foreclose all future inquiry into the duty of maintenance, however affected by changed conditions. Even though the Constitution does not deny Georgia the power to indulge in a policy for itself, it by no means follows that it gives Georgia the privilege of prescribing that policy for other states in which the child comes to live. South Carolina has adopted a different policy. It imposes on the father or his property located within the state the duty to support his minor children domiciled there. The decision in Sister v. Sister lends no support to the contention that South Carolina can be precluded by a judgment of another state from providing the future maintenance and support for a destitute child domiciled within its own borders, out of the property of her father also located within those borders. Here, the Georgia decree did not end the relationship of the parent and the child, as the decree of divorce may end a marriage. Had the infant continued to reside in Georgia, and had she sought in the courts of South Carolina to compel the application of the property of her father found in South Carolina for future maintenance and support, full faith and credit to the Georgia decree applied, and to its own domiciled resident might have been required the denial of any relief, cited from Bates v. Bates and Thompson v. Thompson. But when she became a domiciled resident of South Carolina, a new interest came into being, the interest of the state of South Carolina as a measure of the self-preservation to secure the adequate protection and maintenance of helpless members of its own community and its prospective citizens. The interest was distinct from any which Georgia could conclusively regulate or control by its judgment, even though rendered while the child was domiciled in Georgia. The present decision extends the operation of the full faith and credit clause beyond its proper function of affording protection to the domestic interests of Georgia and makes it an instrument for encroachment by Georgia upon domestic concerns in South Carolina. Justice Cardozo concurs in Justice Stone's opinion. Well, there's what we have right now for conflicts of law for today. Hopefully we get some more custody and child support cases. Those are better than the other civil pro cases. So, yep. So conflicts of law. There we go. I'm gonna be doing a new stream in a minute here. I'm not sure if it's gonna be up here, or if it's gonna be on playback, or it'll stream to YouTube either way. I'll have to figure out how to do it. I'm gonna do some bar prep questions, some bar prep stuff. So, yeah, let me put this stuff away and get the bar prep stuff set up. I'll send a link out to everybody, or be on the YouTube channel everywhere else. If you use here, let me see if I can pull up even the freaking. I don't know if I can drop a playback link in here. Let's see if I can do this. Oh, this will work. Copy that. All right. Before we go here, people in the chat, you want to go to the stream or the playback thing? It's pretty cool because you can actually like ask questions and like actually put your mic on. It's like YouTube. Like I'll be up here or whatever and doing bar prep questions on part of the screen, but like if people want to come ask questions, they can actually like join the stream live and like use their microphones or their phones or whatever, or chat live. But you can actually like more people can come into I can bring people into the room with me, like from the app or from the browser. So if you want to check it out and see, I'll be doing bar prep questions. So if anybody has bar prep questions or questions about law school or admission to law school, or which law school to choose or not choose, or any questions in general, or want to talk, I'll be there in a couple minutes doing a bar prep stream. So I'm going to end this now, but we'll talk to you and see y'all soon. God bless. Tip your waitresses, tip your waitressers, hostesses, hosters, bartenders, and astronauts. Have a good one, folks.